All set.
Good morning, everyone. It's our November 30th edition of Bar Talk, and there's a lot of changes going on. So many so, I'd say we're almost back to March levels of pandemic management orders. And I'll try to keep to the agenda as best we can. We do have a guest speaker, Josh Tardy, that's going to be joining us too, as soon as we're done with our executive and emergency order announcements. So we are still in a civil state of emergency, and that was proclaimed again by our governor on, I think, just before Thanksgiving, on November 24th. We also have some closures going on. I just happened to review the judicial branch website, and it appears that the Augusta, or I guess you call it the Capital Center Judicial Center for Superior Court as well as District Court are closed from now until the 3rd of December, I believe is what it said. You can find these announcements on the judicial branch website too under court closings. The other thing that I found was kind of interesting for those that don't know, it appears that you might be able to sign up to receive notices of court closings. So I encourage you to take a look at that, especially as we head into the winter months. And hopefully my voice won't be as scratchy as it might sound right now going forward. Let's see. So last week we received an email. It was actually late Monday from Justice Meade indicating that he was proposing new amendments to PMO SJC 3, as well as a new PMO called PMO SJC 3A. 3A pretty much applies to protection orders, protection from abuse, protection from harassment orders, and PMO SJC 3 sort of its changes sort of meld for the same reasons. And what these two PMOs are attempting to do, it appears, and these are draft PMOs that are intended to go live tomorrow. They essentially address the ability to email filings, not e-filing issues, but emailing filings. So, and they would be just about anything that don't require a fee. So in other words, if you want to start a new action that requires a fee, you're going to need to deliver that or mail it to the court. After that's been established and there are filings to make that don't include fees, you can, of course, email those pursuant to the instructions there. And remember, I think it was PMO SJC 2 subsection G has permitted our ability to e-sign or sign by typing our name with a /s/ to enable us to not to have to wet signature those documents that we send to the court. Let's see what else we have on the list. For those that have not seen the standing order regarding small claims, we did, I believe, connect you to this or link it to our website. It was signed by both Chief Justices of the Superior and District Court. And what it says is they will reject any filings for small claims that aren't done on the new form. The new form was issued in July of this year. And I took a look at the new form for those that haven't. And primarily, it seems that the new form attempts to detect whether or not you are classified as a debt collector. And if you are classified as a debt collector, apparently there are additional fees that you need to pay in order to file an action or a statement of claim. And you're kind of walked through that in the form So for those of you that might be wondering whether or not you'd be classified as a debt collector, either as an attorney or your plaintiff that you represent may be, then you should review Title 32, Section 11002, subsection 6 and subsection 5. All right. Are you hearing me all right, Angela? Am I still scratchy?
You're still scratchy. I'm not really sure what the problem is.
Well, let's hope it corrects itself after Josh gets on. All right. So there are a whole bunch of things to talk about. Like I was saying, I'm probably not going to address everything that's on our hit list here because we want to get Josh on, but you should know that there was a press release that went out on the 24th of November from the judicial branch that specifically talks about e-filing. So I wanted to get this message out to you because it occurred to me that as I saw this announcement and then saw an email that came out from the business docket, that it's going to affect us all statewide. And that is that effective November 30th, if we are engaged with BCD statewide, the Tyler Technologies Odyssey platform, in order to look at filings in that BCD and also to make filings pursuant to e-filing. Please take a look at that public announcement, which is, I think, posted to our website. I'm not sure it is actually on the press release website of the judicial branch yet. I think I looked for that this morning and did not see it. I could be mistaken. And
it is posted to our website, and I believe it is on their website as well.
Okay. All right. So I think I hit all the big ones that I wanted to hit right now. There are some requests for proposed revisions that have gone out regarding SJC3, the new SJC3A, and SJC8. And are either Amy or Julie on the line right now from the judicial branch?
Yes, this is Amy Quinlan.
Hi, Amy. I was just going to ask, I'm putting you on the spot. Have you been receiving feedback regarding those requests for proposed revisions?
I'm not sure whether we have. I haven't received feedback, but it may have been sent elsewhere.
Right.
We put my email address on there too, and I haven't received anything yet.
Okay. Well, I encourage you to take a look at those proposals, and anyone that needs any of that info emailed to you, we do that for our members that can't get access through the judicial branch, if that's something that we can help with after our talk's over. And given that, I'd like to transition to our guest, Josh Tardy. And Josh is the, among other things, he is the chair currently for the commission that oversees the Maine Commission on Indigent Legal Services. And there was an OPEGA report that was made public this month. I believe it was November 20th. It was at least posted on the website. And there are a few things that it talks about. The posting on the website was 54 pages. I had the chance to peruse it. And Josh was nice enough to join us. One of the things that I just had it up here. All right, so one of the things that I wanted to start Josh off on was that apparently there was a directive for MCILS to essentially investigate either through its own means or through other means 5 areas. And it looks like OPEGA investigated 2 areas. And they comment that it's the adequacies of systems and procedures to address, process, and investigate payments and expenditures, and then the adequacy of oversight to investigate essentially or oversee the operations thereof. So with that, Josh, if you could join us, give us essentially a little overview of what it is that you and the commission do, and then essentially what the report requires of us, what essentially it addresses, and then where we go from here as a state and a commission. Josh, take it away. Josh,
Josh, you're
doing
muted. There you go.
You'd think that after 1,000 Zoom meetings, I'd learned to do unmute as a first step. But good morning, everybody. And I'd like to thank Attorney Dave for the invitation to join Bar Talks this morning. And I'd like to greet all the members, fellow members of the Maine Bar. I'd also like to start out by thanking all the members of our bar who accept court appointments and are part of the Maine Commission's rostered attorney list. Been in the front lines of this pandemic, and I believe representing indigent persons in Maine is public service of the highest calling. And I thank each and every rostered attorney for their resilience, their flexibility, and their passion for the cause in representing indigent persons. And I also want to thank the firms and colleagues, partners, if you will, or associates, members of the legal organizations of rostered attorneys for supporting that public service. Just as a brief overview, as requested, prior to 2009, oversight for Maine's court-appointed attorneys was done by the judicial branch. In 2009, by an act of the legislature, the Maine Commission on Indigent Legal Services was created. It originally had a 5-member commission. That was changed as the commission and the delivery of indigent legal services came under the microscope and subject to criticisms. It changed in 2018. The legislature, as a result of studies and recommendations to reform our system, created a larger commission. And now by design and by statutory construction, the commission consists of 9 commissioners, 7 voting members and 2 non-voting members. And I would note there is a vacancy right now, and your association president, Attorney Day, has reached out to me and has reached out to the governor's office about the need and desire to fill that vacancy. And I appreciate that, Attorney Day, that communication. But by statute, our commission is tasked now with the oversight of rostering, that's eligibility and the rostering of attorneys for court-appointed cases, which involves criminal cases, child protective, juvenile matters, involuntary commitments, and matters like that. We're in charge of the eligibility for that roster. We're in charge of training and supervision of the attorneys that are on our roster. And we're in charge of monitoring and ensuring and processing the payments that are submitted for the work that is done on behalf of indigent persons. This new commission, which was created by the legislature in 2018, it took about a year for the governor to appoint 8 members of this newly constituted commission, of which I'm honored to be serving as chair. And there is, as I've noted, a vacancy. Maine indigent legal services delivery has been under the microscope, in particular, over the past 3 years or 4 years, if not longer. There are very notable examples in our system of attorneys who have allegedly misbilled and overbilled. There's concerns about our transparency and accountability at the commission level and our ability to supervise and regulate the attorneys we're tasked with regulating. And we are definitely a work in progress as it relates to that area. The new commission has been working really since August of 2019 in trying to enact affirmative reform measures that will try to improve our system delivery on whole. We have formed working groups, subcommittees, if you will, that are dealing with various topics. For example, I work on a subcommittee that's dealing with the training. We have a financial transparency and accountability subcommittee, and we have a practice standards subcommittee. And very importantly, we have a subcommittee that is looking at the development and establishment of a public defender model here in the state of Maine. The commission meets at a minimum monthly. We, because of our workload and because of the challenges that we all face with the pandemic, we've met more than that over the past 3 or 4 months, and we plan on continuing to do that as we try to promulgate and enact rules that we think are reform measures that will improve the delivery of our legal services on whole. And we are coming into a very, very important budget discussion wherein we need to convince the chief executive, Governor Mills, as well as the legislature, that we are underfunded, that we are in desperate need of additional funding for office staff at the commission. And we also need to expand what we do for quality legal services by creating a appellate, statewide appellate public defender office. And we are also advocating the establishment of a Kennebec County specific pilot project, if you will, public defender office, and so that we can remove Maine as an outlier as one of the only states in the country that doesn't have some version of a public defender model. We are working hard on improving the initial training for attorneys who want to join our roster, and that is in process. Historically, the commission provides a 2-day seminar for those who want to join our roster. That is going to be bumped up in time. We anticipate a minimum 5-day required seminar, and that has gone out right now in a preliminary request for proposals. We've made a preliminary award, and we're looking forward to someday when the courts open and society reopens as a result of the pandemic, that when we get back to business as usual, that we'll have upgraded, more robust training. The report to which Attorney Day referred to is the OPEGA report. OPEGA is the Office of Program Evaluation and Government Accountability. That is a nonpartisan creature of the legislature. That's a watchdog, if you will, that was tasked with looking at our billing systems and the management systems that we have in place to review attorney vouchers and to hold those who overbill to some level of accountability. And we have acknowledged all along that that our system needs to be improved, that our standards need to be more clearly communicated to the rostered attorneys who bill, and that we need more staff who can devote additional time to reviewing attorney bills and to try to ensure better compliance and to try to bolster our public confidence in the work that we're delivering on behalf of indigent persons And so that's my overview, Attorney Day. And I do believe that I had a tip that we have a bunch of questions, and I'm happy to answer questions.
That would be great. I'm not sure how my speaker's working now. I tried to move a little closer. Good. So Angela is sort of our facilitator. So if she's got some questions, we can start in with those. I appreciate you and everything you're doing to address the report that came out. I do have something I just wanted to follow up with, since I guess I'm here to moderate it. Did you had mentioned going after potentially a public defender office in Kennebec County? I think I noted in the report that there was one that was almost a pseudo public defender office that might have been created in Somerset. Did I see Somerset County MCILS contracted with, was it 3 attorneys to provide services up in that area?
Yeah, so prior to 2018, the Somerset County Defender Project was a contract that 3 or 4 Somerset County practitioners had as a co-op, if you will, with the prior commission. And so that was a model that some states use. It was that contract was not renewed. It had some it was criticized by the Sixth Amendment Center report, Tad, that came out a couple of years ago, and it was criticized for its issues related to inherent and apparent conflicts of interest, and so the prior commission did not continue that contract.
So the ideas that you had mentioned that have been generated out of your subcommittees, such as the Public Defender's Office potential in Kennebec County, when would that be like presented and potentially acted on? I assume it's going to require our legislature, right?
It's a great question, and it's part of our biennial budget proposal that we have already submitted to the Chief Executive, to Governor Mills and her Commissioner on Administrative and Financial Services. And what we're recommending is, rather than a statewide trial level public defender office, is to take it incrementally. And we're dealing with a single county. Our proposal is Kennebec County, and we're establishing an office. We'd like to establish an office that would create 9 attorney positions and the requisite support staff that goes with that. And that's certainly what is the requisite support staff to support 9 attorneys in a countywide public defender office is a subject to debate. Some people think that we should be asking for more office staff and investigators, if you will, to try to mirror that which is delivered by a district attorney's office, for example. But we do have that proposal in. But to your question, the biennial budget will hopefully be enacted by sometime in April, May, or June. I think we're going to be closer to June, and it will be for implementation after that biennial budget takes place. And so that is yet to be determined, but I would say realistically, if we had our way, it would be sooner than later at the start of the next fiscal year, which is July of next year.
Thank you, Josh. Angela, you had some questions there? Go for
I do.
it.
One of them actually had to do with what you were just talking about, so we're gonna go forward from that. So I have a few here that are coming in. Has MCILS heard anything more from the court about requiring appointed attorneys to appear in person for certain types of proceedings while allowing judges and DAs to participate remotely? And if not, is this a matter which should be referred to the Judiciary Committee when the new session starts?
It's a great question, and our staff, Director Pelletier and Deputy Director Maciag, have daily communications with the judicial branch, assessing the COVID risks, the health-related risks. We know that that's an issue, and it's I would just say this: it's a daily conversation, and we have instructed rostered attorneys that if they are not comfortable being in court, We completely recognize that, and we need to have them put their safety first. But yes, if it's an issue that's ongoing, it's something that the legislature may very well have to take up.
Do the proposed reforms include any increased responsibility for the use of the roster list at the court level? In other words, will the power to assign cases remain with the clerks?
It's a great question. Really, the power to assign the cases should come through the commission. And we're going to have better communication with the clerks and making sure that rosters and specialized rosters are matching up to the clerks' referrals. But that's an issue that we need to have a better system of communications in place, and it's a work in progress.
Have there been any findings to suggest that the quality of representation for indigent persons is substandard?
Findings, I don't know about that term, but I know that there are certainly examples where there have been subpar performances, and I think that is a problem that the commission on whole owns because of our lack of oversight systems being in place, our basically inadequate supervision of attorneys. I think it is in many respects budget related. Right now, our office staff of central office is 4 humans, and they're reviewing 2,500 to 3,000 vouchers a month. And that is almost a half-time job for our existing staff. So for us to get out into the field and actually monitor and supervise and provide the resources on a case-by-case basis is going to require additional staff, and that is part of our biennial budget request. I will say this though, that for the stories we hear about inadequate representations, I think that some of the finest representation that people can have come from rostered attorneys, and some of the finest attorneys in state are part of our roster.
So basically, if the question was followed up, is the largest issue the lack of government financial support?
I think it is. I think, though, that notwithstanding what our funding is, that the existing commission is dedicated to making sure that we're going to be the best we can be with whatever dollar that's appropriated and allocated to us.
The last question I have so far is, what is the status of hiring a new director?
It's a great question. So we are in the process. We have a search committee of which I'm chairing, and I've got great participation. Commissioner Michael Carey and I are on that on behalf of the commission. Deputy Director MCILS is on that, and we have members of the bar, Jamesa Drake and Zach Hayden, who are helping us with this search. We anticipate a national search. It could take 60 to 120 days. We're in the process right now, and I would say within the next week to 2 weeks, of actually posting the job description and starting the advertising and publishing of the job vacancy. And we are also looking right now at trying to attain an interim director.
Okay. Josh, I do appreciate all the time you've given us. We're kind of running out of time for our hard stop at 11:30. I'm just looking here. As far as any recommendations that come out of the commission, one of the questions that came in was if there's a public defender's office, would that require a statutory change compared to how we're currently implemented through the commission?
Well, the easy answer to this is sort of inside baseball at the legislature. And if it's part of the budget, it's part of statute, and so therefore it would be part of that budget document. But we think in order to go there, that whether we need a statutory change or not, we need the legislature's full endorsement of this process. Whether you think that the commission has the authority to do this or not, we want to do this in partnership with the legislature and the chief executive.
Josh, hey, I really appreciate the time you've given us. You're welcome to hang on for the 60 more seconds we're probably going to share with people. And then thanks again. Please, we'll stay in touch. And if there's anything that you think is important for us to help post, for instance, for this job, we can do that too.
Thank you very much, and stay safe, everybody.
Thank you. All right, Angela, can you give us business side updates?
Yes, so just thanks, Josh. Again, real quick, we've got CLE proposals that we need for the Winter Bar Conference. The deadline for those is at the end of this week, so please get those in. We have a couple of, we have more than just a couple, but in particular wanted to point out a couple of CLE programs we have going on this week. We've got the bankruptcy, the next, it's actually a series. The next one is up on December 2nd. And then we have another H&D program coming up on Friday. So if you have not got your H&D credit this year, join us for this program. You can, those links will take you to the registration pages. So once this gets posted to the web, our website, you'll be able to click on those. And finally, next Monday, we have Chief Justice Meade joining us.
Great. Thank you very much, Angela. Thanks for everyone for tuning in. My mindfulness brought to me some thanks over the weekend that we had for our family and friends. I just want to share that with you. And we hope to share Bar Talk with you again on December 7th with Chief Justice Meade. Thank you.